All right. Hello, everybody. Welcome to the CLE, handling your very first DUI. This is a Florida law practice specific CLE presentation. My name is Adam Rossen. I am the founder and CEO of the Rossen Law Firm. Welcome, welcome, welcome. We've done this a few times before in the past, few years ago, but this time we have a very special treat for everybody. Not only are we going to have myself and a few other members of Rossen Law Firm speak, but we have a prosecutor here. So let me go ahead and show you guys the agenda for today. Okay. First session is going to be mine with session number 1, how to issue, spot, and work a case pre-trial. We're going to go 45 minutes to an hour on that, have a little quick break. Then we'll jump into Manny Sarahovinich, who's the managing partner of Rossen Law Firm, and he's going to talk about building a strong defense foundation. Number 3, we're going to have Armand Murach from our firm come in and talk to basically the basics of DUI science and field sobriety exercises. That's a great presentation. I know it's a great presentation because I used to do that one. And then for session 4, forget about us, sessions 1, 2, and 3. But session 4, we have one of the most experienced prosecutors coming here to teach and talk to you guys, Garrett Berman. I've known Garrett for over 15 years. Garrett was my trial partner when we were both prosecutors at the Broward County State Attorney's Office. So I'm so excited to have Garrett come in. He's going to talk about the DUI trial experience, and he will be able to balance us out with a lot of prosecutorial perspectives. Garrett is now, I don't know, I'm sure he'll introduce himself with his official title and everything, but he's the head trainer for the FPAA, which is the Florida Prosecuting Attorneys Association. So he goes in and he speaks and trains all of the prosecutors all across the state of Florida on how to be better prosecutors and better attorneys. So really cool. We're very excited what we have for you guys today. So let's kind of just jump right into my session 1, how to issue, spot, and work a case pre-trial. But before we do, at least let me give a little basic introduction of who I am. So as I said before, my name is Adam Rossen. I am the founder and the CEO of the Rossen Law Firm. I'll tell you a little bit about us. So we are primarily based in South Florida. We've been around 17 years now, which is kind of crazy. And we exclusively handle criminal defense and DUI defense. So we handle anything state court related in South Florida. We handle federal and white collar cases nationwide. And throughout the state court practice, about a good 25% at least of our practice is DUI, and we actually love DUI. And what I want you folks to understand is there's a big difference between lawyers that are well-versed and experts in DUI versus criminal lawyers that just will handle a case or two or handle DUIs but not do it very well. And what we wanted to do, we love training and teaching because we've had the benefit of training and teaching from so many other people, but we really want whoever's listening to this, whether you're a criminal lawyer who wants to add some more DUI work, fantastic, amazing. We want you to learn. If you're somebody else, maybe a family lawyer, and thinking, well, I'd love to start to learn, or something about learn more about DUI, where you can maybe take those on. Great, okay, we want you to learn. It's very complex, very highly nuanced, but we like to kind of break things down in a easily digestible way for everybody, so that way you guys can learn and understand. All right, and that's who I am, and that's what we're gonna do today. So the very first thing, okay, when we're looking at how to issue, spot, and work cases before trial, okay, very first thing you're going to get is going to be the PC, the narrative. In Miami they call it the A form. Okay, it could just be the complaint affidavit. A lot of the different police departments and jurisdictions have a different name for it, but it's really going to start off as the probable cause affidavit. Now, usually in DUI cases, the PC or the A form, it's written out in larger detail than most other cases. We've had many domestic violence cases, batteries, burglaries, robberies, so on and so forth. And we're talking 3-4 sentences here, which is really just the probable cause that the police had, and they need that to send with the arrestee to jail. Okay, the jail will not accept somebody without a sworn probable cause affidavit outlining why there was probable cause to arrest that person. But in DUI cases, the PC is usually much more detailed, which is great because usually that's the very first thing that we're able to get: the PC, the narrative, and the tickets. The tickets are just going to have a little bit of information on there. But the more information that we can get in the very beginning, the better it is. And so you, as the DUI practitioner, the DUI defense practitioner, you're going to be able to get, right away from the clerk of the court or within a day or two, or your client, the PC and the information, not the criminal information, but the PC that gives them information and gives you information about what they were charged and arrested with. Okay. So that's always going to be the first part to look at. But what else is there going to be? So we're going to have the PC, we're going to have tickets. Okay. The DMV, the driving record. That's going to be important as well. And why is that important? Well, that's not going to be so important for issue spotting, but as far as defending your client and getting to really know your client and see what we're working with, that's going to be important because a lot of people, especially with DUI, people don't know if they were convicted or not. Maybe they were previously arrested for DUI in a different state. Okay. Well, just because you're arrested doesn't mean it involves a conviction. So you need to see what's on the driving record. Okay, and the driving record is going to be, comprised of their administrative hearing process and quite possibly the criminal hearing process. And we're not going to go into all the details for this basic presentation today about all the differences between the DMV process and the criminal court process, but just to let you know that that the DMV driving record is going to be very important, and that can very well control what happens. All right. Also, uh, other states call DUI different things. I'll give you a very quick example. So the state of New York has a traffic offense that's a lower offense than DUI. It's called DWAI. And in the state of New York, DWAI is, again, it's a non-criminal traffic infraction. Usually, when a DUI arrest gets reduced significantly, it's just that traffic infraction. However, the state of Florida looks at that charge, DWAI, which is non-criminal in New York, and they look at it as if it were a prior criminal DUI from the state of Florida. So there's a lot of different things that this driving record can and will tell you. So that's very important. Again, that's not so much for fighting and beating the case, but you need to know, is this truly your client's second DUI, right? Second DUI case? Do they have a previous conviction or two previous convictions, or do they have one conviction and two previous arrests? Because that's a big difference. A little more advanced for today, but I wanted to talk to you folks about that. All right. Medical records, if any, especially in obviously crash cases in blood or urine cases. Okay, that's going to be very big. Breath results. Okay, and when we talk about breath results on breath cases, there's going to be all these different forms from FDLE, agency inspection forms. There's so many different forms that come from there, and you're going to want to need to get all of that information. The good news is most of it's there on the FDLE website. You can go and poke around and take a look from their breath testing protocols, and it's a really good place just to start and take a look at all the different things that are on there. Okay, and there's going to be urine and blood reports as well that in those crash cases. One thing that's not on this list that's very important these days: body worn camera. Okay, nowadays we're talking 2025. Most DUIs are going to be most incidences with the police in general, unless you're talking street level narcotics teams, because usually street level narcotics, they're still not wearing body cameras. Different talk for a different CLE, but DUIs are now on video. Even 10 years ago, in 2015, in Florida, it was rarely the case unless it was a task force. But now pretty much everybody has body cameras. So you're going to want to get that information. You're going to want to review that in a very detailed way as you're reviewing discovery and looking, well, hey, what am I going to do with this case? Do we have any motions to suppress, right? Is this going to be a good case for preparing on the way to trial? So there's a lot of things with this that's very key, even to the experienced practitioner. To do these cases right, you have to really take a slow and methodical approach. You can't have a body camera just playing in the background while you're listening, kind of half listening. You need to be watching it intently, watching every single camera, every single angle, looking for conversations, even when your client is not in or not on the body camera, right? Maybe he's sitting in the back seat of he or she's sitting in the back seat of a police car. You want to be listening, because we've heard many times over and over and again where cops are just giving us gold on the defense side. They're making inappropriate comments. They're talking about things that completely contradict what's written in their report. So you really want to go through that with a fine-tooth comb. Okay, now let's move forward. Okay, so DUI motions. Okay, when we're talking about motions here, usually we're talking about motions to suppress evidence, primarily under the Fourth Amendment. And our firm's philosophy is just like Jedi Master Yoda. Okay, do or do not, there is no try. Okay, there is no, well, I'm going to try to file a motion or we should file a motion. Okay, I want you guys to be looking for motions. Motions magically appear the more you know about them and the more that you really look for them and understand them. And let me tell you, motions to suppress and motion practice is a great way to win DUI cases that are otherwise factually, quote unquote, unwinnable. Okay, when we're talking about, again, high level DUI practice, but even beginner level, the better you are with motion practice, the better of a DUI defense practitioner you will be. And the first and biggest, and what I always say, the best way to win a DUI case is through a motion to suppress on the traffic stop. You always looking chronologically, I still think is the best way in DUI cases. It might not always be the best in some complex murder cases, or truly every case is different. That is one of the beauties of criminal law. But on DUIs, you do want to look at it chronologically, and you always want to start with the traffic stop. Now, why? Well, if the stop is suppressed, then everything after the stop is fruit of the poisonous tree and is gone as well. So what does that mean? Okay, well, in a DUI case, all of the observations about the client, usually odor of alcohol, bloodshot watery eyes, slurred speech, the poor performance on physical exercises, the FSEs, a high breath test, a urine test, a blood test, all of those things come chronologically after a stop. So again, if the stop is illegal, then all the evidence gets thrown out. It does not matter if your client, threw up on the police officer, was running around naked, anything like that. That does sometimes happen in these cases, or makes startling, very bad admissions, okay, to drinking. The stop's bad, the whole case is bad. But traffic stops are hard. Okay, they're hard. They're hard to win. They're hard to file motions. And going back, what are we in now? 30 years or so. I can't believe it's been 30 years. I was still in high school when this case came out, but Wren versus US. Okay. This was a United States Supreme Court case that completely flipped the script on how we look at traffic violations across the United States. Okay. Previous to Wren, the subjective intent of the police officer could have been a factor depending on how the court analyzed it. And we really were allowed to get into the subjective mindset of these police officers. Last almost 30 years, no more. Okay, nonsense run. So what does that mean? Okay, that so long as the police officer has probable cause, has PC that a traffic violation occurred, the subjective intent of the police officer does not matter. So you can have a police officer who is sitting outside of a bar waiting and saying, look, I know that people come out of this bar, they come out drunk, and I wait for, it's a 35-mile-an-hour zone. I wait until they hit 36, 37, 40 miles an hour, and I light them up and pull them over because I think they might be drinking, but I do it because of the traffic infraction. Under Wren, doesn't matter. Okay. So that's something really good to know. Now, when we have these other cases, like Heard, okay, citing to Holland, Holland's the one that brought Wren to Florida. Okay, it's objective, again, subjective knowledge, motivation, interactions, intention of the police officer does not matter. These are some other cases, okay, that we have here. Now, instead of kind of reading this, to you guys, I want you, take these cases down, okay? If you're going to practice DUI defense, you have to have a subscription to Florida Law Weekly, to the supplement, okay? So much of what we do in county court with these DUIs is shaped and influenced by the local circuit. So in Broward County, we're the 17th Judicial Circuit. In Miami, we're the 11th. In Palm Beach, we're the 15th. And as kind of a quick aside there, to me, it's always great when you file a motion to suppress and you're arguing something. And, the cases at the DCA level, they're not, the likelihood of a DCA case fitting your facts perfectly is going to be rare because there's less appeals cases that go to the DCAs, okay, and get and get adjudicated at the DCAs. So there's going to be a tons at the circuit court, reviewing from years and years and years of the county court. And that's where you're really going to get the ones that are very close in facts. And what I love is going in front of a judge. Let's just say we're in the 17th Circuit in Broward County, and the judge saying, well, Mr. Rossen, do you have any DCA cases that support this, or do you have anything that's more fact specific? And I say, well, Judge, there might not be anything from the fourth, but I have a case from 7 years ago from the 17th Circuit. It's not officially binding precedent, but guess who the judge was? It was you, and you got overturned, right? Or you were affirmed. Or this was your order on a motion to suppress with very similar facts, because Florida Law Weekly, they'll have the judge's orders, and they can have the circuit court's opinions either affirming or reversing the county court judge. So it's great. You have to have that here in DUI defense. It's so crucial. Okay. And when we're talking about Heard, okay, and some of these other cases, one of the great ways to file motions to suppress an attack case is on the failure to maintain single lane violation, which is more of that drifting and weaving driving pattern. Okay, for example, speeding factually is not, in my opinion, not that big of a deal to a jury. Okay, speeding is not a sign of impairment. People speed all day, every day, even if the speed is pretty egregious. Especially when there's speeding and no drifting and weaving, because what I always like to do in a trial setting is argue and say, look, it's harder to drive a car going 80, 90, 100 miles an hour. Maybe my client was being a bit of a jerk that day, making poor choices as far as how fast they were going. But driving a car very fast is actually is an intense sport. NASCAR, Formula One, it's difficult to do. And if they're not drifting, weaving, or swerving, that shows that their normal faculties are there. So factually, speeding can be a good factual argument. But on the legal side, speeding is a very poor legal defense. There really is virtually no defense. Well, there's always some little defenses, but it's very, very, very difficult to get a case thrown out on a speeding allegation on a legal technicality or a violation of the Fourth Amendment. However, these failure to maintain single lane cases, the drifting and weaving, factually, those are a little tough, because what do people think when they see somebody drifting and weaving, right? And especially early morning. Oh my God, he's drunk. Stay away, right? And if there's a passenger in the car, they'll say, okay, let's slow down. Let's stay away. Let's be careful. Right? No, it could be the person's lost. They're looking on their GPS. It could be that they're texting and distracted. But generally, the assumption is that that person is impaired by alcohol always. But legally, these cases are pretty good. Okay. And these cases follow one of two different patterns as far as the failure to maintain single lane. It's, well, is there probable cause that the failure to maintain single lane statute was objective probable cause that the failure to maintain single lane statute was violated? Okay. If so, other traffic needs to be affected in order for that to be true. And if not, if no other traffic was affected, then is there reasonable suspicion that the person was ill, tired, or impaired, and that the police were using the community caretaking function? And in my experience, far and away, the most amount of issues litigated on stop issues in the state of Florida are on this failure to maintain single lane statute, because the way that it's written um, can be very advantageous from the defense, meaning you don't actually have to stay in your lane. You can drift and weave a little bit so long as A, no other traffic is affected, and B, the police officers did not think that you were having some kind of medical emergency or where they needed to really use their community caretaking function. So because of that, we have dozens upon dozens of cases, especially in Florida Law Weekly Supplement, with similar fact patterns and fact patterns that you guys can probably use in your cases. So that's always something that I want every DUI defense practitioner to really be aware of. And the case that's most cited to this is the Crooks case, Crooks v. State. It's from the second DCA from almost 30 years ago. It's not a U.S. Supreme Court case, or I'm sorry, a Florida Supreme Court case, but it's the Crooks case that's really talked about these driving patterns. Okay, and here's some other ones. This Alfred, case. Courts have held a stop to be invalid when a vehicle moved to its right and crossed the right lane line by several inches to 1 foot, approximately 6 to 7 times in a weaving pattern when no other traffic was affected. Now that's directly from Broward County. Again, long time ago. Okay, it's also pre-Ren, so people can distinguish. Well, I even though it's pre-Ren, I think it's still distinguishable. And still applicable after Ren, because the no other traffic affected is the objective basis or the objective issue here when we're talking about Ren, and if no other traffic is affected, then there's no PC for the stop under that violation. You have to go again to the community caretaking function. Okay. And again, understand this is, intended to be a basic primer. We could probably do 8 hours alone on stop motions. Well, not probably. I know we can. So this is again just kind of that initial primer. There's so much amazing information out there that if anybody on any of these topics wants help on, I know, Garrett just has so much information and knowledge about case law. So do we at the Rossen Law Firm. So if anybody ever wanted to reach out to get more information, I can tell you, you can always reach out to me, Adam at RossenLawFirm.com, and we'd be happy to give you, some access or some cases and different ideas. We love kind of nerding out on this stuff. All right. So investigative stops. Now, police can stop and briefly detain a person for investigative purposes, but the officer has to have reasonable suspicion supported by articulable facts that criminal activity may be afoot, okay, even if the officer lacks probable cause. Okay, so we're talking about reasonable suspicion. It's a lower standard than probable cause. And, the police can basically just, again, it's a brief stop and detention just to investigate and to really see what's going on. We're not talking a full-on detention. We're not talking a full-on arrest here. Okay. And this is from Florida Statute 901.151. Whenever any law enforcement officer of the state encounters any person under circumstances which reasonably indicate that such person has committed, is committing, or is about to commit a violation of the criminal laws of the state, he may temporarily detain such person for the purpose of ascertaining the identity of the person temporarily detained and the circumstances surrounding his presence or her presence abroad, which led to the police officer to believe that he had committed, was committing, or is about to commit a criminal offense. So what Florida did in making this statute is they basically just took the the reasonable, they basically just codified, okay, and took it out of case law and said, nope, it is a legal, legislatively created statute in Florida that allows for investigative stops. So that is really important to know. Okay. Now, when we're talking about investigative stops, we have some things called the fellow officer rule, and we're going to go just a little bit in detail on that. What we have on the fellow officer rule is that police officers must see each and every element of the crime. So we have driving, okay, and in DUI, we have driving. We have under the influence of alcohol, chemical, or controlled substances to the extent that your normal faculties were impaired, or a breath or a blood alcohol level of 0.08 at the time that you were driving. And so in the fellow officer rule, what it allows is one officer, such as maybe the stopping officer, okay, to stop, see the driving, okay, and then call for backup or a DUI, I'll put it in quotes, specialist, okay, somebody who likes to do DUIs, who may be on a DUI task force, who may or may not have advanced training, to come in and then take over and handle the DUI investigation. And in that particular instance, Officer A, the stopping officer who witnessed the driving or the actual physical control, must speak to Officer B, who's going to then do the signs of impairment, probably do the field sobriety exercises, and then eventually make an arrest. And that first Officer A must speak to Officer B before Officer B starts doing their investigation. And the law allows Officer A to impute their knowledge to Officer B. Okay, so that's more or less a kind of an easy version and simplistic view of the fellow officer rule. Okay. And one of the big things that you're going to hear in these cases, kind of buzzwords, totality of the circumstances, totality of the circumstances. So, okay, it's it's talked about in criminal cases. These are things that prosecutors and police will always talk about. These are certain buzzwords. But when we are evaluating this, more importantly, not really us as defense lawyers, but even when judges are evaluating this or jurors, they're going to be told over and over again to evaluate the totality of the circumstances, how one piece builds upon the second piece, builds upon the third piece. And so it's the same with getting that information or getting that totality of the circumstances when the prosecutors are trying to prove somebody's guilty beyond and to the exclusion of every reasonable doubt, but also when the court will be analyzing reasonable suspicion or probable cause. So it's really good to know, that legal buzzword of totality of the circumstances, and how reasonable suspicion and probable cause is not just one thing based on one piece of evidence. It's usually based on everything. And one of the tips and tricks that we like to do in my firm is we like to kind of flip that around, especially when we have a good case where what the officer didn't really make sense, or when an officer so blatantly ignored certain set of facts or circumstances that could be um, exculpatory for our client, or could provide really good reason as far as maybe why they struggled with uh, field sobriety exercises, which we'll be talking about throughout this presentation. It could be something where a client had an injury, and they were never asked if they had an injury, or the officer only asked if they had a disability, not an injury, and there's a big difference. Or client said, yes, I have an injury, and the officer did not give seated field sobriety exercises. And when we're able to really question these police officers and say, well, okay, and it doesn't even need to be a hard cross-examination for a lot of these police officers. It could just even be just asking them and just saying, listen, officer, explain to the judge, and maybe during a motion to suppress, or even to a jury at trial, explain to me how you factored that into the totality of the circumstances. And they may give you some very weak, generic BS answer. And then you say, okay, well, explain how much weight did you give that? Did how did you compare that to other pieces of evidence? Right? Did you give it more or less weight? Explain why you chose to believe that this was less important. And they can't do it most of the time, because most of the time the officers, what they're doing is they're following a script. Okay. And they're not really thinking it through with intention. So, that's a common tactic for us at our firm. It's not something everybody does, but I really love questioning those officers. And, it depends on the mood I'm in, depends on the officer, if we're going to really go at them in a hard, leading way on a cross-examination, or if we're just going to ask them and let them fumble around with it. And that is something that definitely needs to be practiced. Okay, next part on investigative stops. We're going to now talk about anonymous tipsters and confidential informants. So we get this a lot in DUI, and these are basic fundamentals of criminal procedure that's been around for a very long time. Uh, Confidential informants have a higher indicia of reliability. So in a DUI context, okay, it could be a situation where a confidential informant is somebody who calls 911, gives all of their information, is actively following a car, or they've stayed on scene to speak to the police officers. Okay, those are confidential informants. Okay, the police are going to deem that to be much more trustworthy than just an anonymous tipster, right? Somebody calling 911 saying, hey, there's a red car driving erratically on 995, click. Okay, go look for him. It's by Glades Road in Boca. Okay, on 995. All right. And that has a lower indicia of reliability. Over the years, though, especially over the last, maybe I'd say 10, 15 years or so, the courts have been kind of blending the two together and eroding the protections against anonymous tipsters, where now more than ever, they're giving much more discretion to the police officers, even on anonymous tipster cases, to more or less make it much more difficult for defense attorneys like us to file motions on that. So, but whenever you're viewing these cases, what I really want you to get out of this is, as you're reading the PC, going through the full discovery, okay, start thinking about it logically and asking questions. Because one thing that's very important, and I explain this to my clients, and I think it's good for all lawyers to understand this. There's a few different buckets or categories of evidence that we live in, right? The first one, okay, right here is what the cops and the prosecutors think happened. Okay. The second one is a God's honest truth. What really happened, right? If we were that omnipotent being overlooking, kind of like in a movie, and we can see every single thing going on, right? The actual truth. And the third bucket is the bucket that I actually care about. I really don't care about the first two buckets unless our client is innocent. If our client's innocent, then I do care about the truth. But what we really care about is bucket number three, which is, what can the prosecutors and the police prove in a court of law under the rules of evidence and criminal procedure. Okay. That's really all I care about. And so as you're analyzing all these things, I want everybody to be looking at that through that lens when they're looking and evaluating the cases. Okay. The truth doesn't matter, right? It's what can they prove? And when we're working on motion practice, think of it if you've ever been to a fancy wedding and there's an ice sculpture. Maybe there's a right. Talk about drinking. There's a swan that's like a vodka luge, and you pour it in, and it goes through the ice and chills it. And it's really fun and cool. Okay. Well, that ice sculpture did not just magically appear, and it did not start that way. It was a giant, ugly block of ice, and it took somebody hours to chip and chisel, to shave and polish, chip, 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 save, polish, make it really nice and pretty. And over time, it became that beautiful swan. And in a way, that's what great DUI defense is and great motion practice is. Now, in the context of a motion to suppress on a traffic stop, that's equivalent to taking a shotgun and you know blowing the whole thing to pieces. But in a lot of other ways, and some of the other motions that we're going to talk about, it's chip here, chisel here, chip, shave, polish, right? And before you know it, three or four pieces get out, meaning they're not admissible. And now you have something beautiful that you can work with. Okay. But in order to do that, you have to know the fundamentals. So that's, of course, what we're going over. And you definitely need to be on the lookout for situations where there might be anonymous tipsters or confidential informants. Okay. Here's some more cases. Okay. When we're talking about, safety, all right, safety of, right, ill, tired, impaired. Okay. DHS&V versus DeShong, that's a very popular case. Um, these are things as well through your, I want people to look at these cases. These cases are a great start as you're learning about these topics. Okay, these are some of the kind of higher level fundamental cases. And, anytime you're looking at case law, it can definitely take you down the rabbit hole. But this is very important to have a baseline knowledge of and to know, again, what are we looking for? So, okay, if the police, and again, one of the key words in here is a legitimate concern. I think that phrase is very important in these cases because what you're going to have, what you'll see the more you do this, is police officers who, like robots, just spit it out, spit it out, spit it out. Well, I thought they might be ill, tired, or impaired, ill, tired, or impaired, ill, tired, or impaired. And well, in Broward County, by local tradition, we get depositions, which is very rare, and we're very lucky. Whereas the rest of the state, it's very difficult to get depositions. And now, especially that things are on, body camera, it's even harder. But if you do get an opportunity to take a deposition on this case, or if you challenge if you request a formal review and you challenge the case at the DMV, you can subpoena officers and really get to grill them. And, or you just file a motion to suppress and get the testimony at the motion to suppress. But you can really grill these police officers on, well, was this a legitimate concern? Or are they just regurgitating key phrases, like one of those old pull toys where you pull it and they go ill, tired, or impaired, ill, tired, or impaired, or you pull it and then again they go totality of the circumstances, right? Or they sound like a parrot. Okay, parroting those things back, and you can really grill them, um, about, well, was this a legitimate concern for safety? Did they call fire rescue? Right? Did they ask for an ambulance? Did they even ask the person if they wanted it? And if the person said no, okay, well, they said no, but big deal. Do they always just trust and listen to the person? There's so many different things with ill, tired, or impaired. If somebody's sleeping in the car, a lot of times they'll shake cars and they'll break windows to get to somebody in the car, even if a car is lawfully parked in a parking lot. And a lot of that analysis goes into, well, okay, we can tell when somebody's ODing or having a seizure or a heart attack or medical emergency versus when they're sleeping. And they'll use words like passed out instead of sleeping. So there's a lot of things that you can really be creative with and take what they say with a grain of salt and really kind of question it. So all those things matter and can affect, what we're talking about here today. All right, let's go into another topic, the accident report privilege. Now, this is definitely coming under fire lately. Talk just, little bit about very little about some of the changes, because I really just want you guys to understand what it is and traditionally what it's been. So in the state of Florida, Florida places a legal duty and obligation on individuals involved in a car crash to provide information to law enforcement for the purposes of completing an accident report. So you must do that. You're in a crash, you have to speak to them, you have to cooperate. But in exchange for providing the potentially incriminating information, the legislature granted immunity to such statements so that they may not be used in any criminal or civil proceeding against the defendant. So, what does all this mean? Number one, you're in a car crash, you have to talk to the cops. But number two, if any of these things that you must talk about, which goes against your Fifth Amendment right against self incrimination, anything that you say can't be used against you in a criminal or civil proceeding, which is called the accident report privilege. Okay, so we have this privilege, right? How is it used and what does it really mean in practice? So when somebody's involved in a car crash and they're suspected of DUI, the police have to follow a certain procedure. They have to what's called change hats. Okay. And the big case that we like to use is Marshall, which is funny because Marshall is it's a third DCA case, which now a third DCA is Miami, from again about 30 years ago. But the Marshall case is like one of the smallest little cases. Okay. Well, actually, I think Marshall went up to the Florida well, the third DCA case then went up to the Florida Supreme Court in '97, and the Marshall case is very small, but everybody uses it. And what it says is step one, officer must change hats, which is say, look, either myself or the other deputy or the other police officer, we are done with this crash investigation. We're now doing a criminal DUI investigation. Okay? And then they are supposed to immediately, contemporaneously read the Miranda warnings, okay, which is basically, you don't have to talk to me, right? Okay, we know what the Miranda warnings are. Anything you say can be used against you. You have the right to an attorney, okay? If you start talking to me, you can change your mind at any time. And start going through the Miranda warnings. And as a very common practice, the police officers will change hats, but they will not read Miranda. And some officers don't know that they were supposed to, but most officers, from my conversations with them, make a deliberate decision not to read Miranda. And the reason that they gave me over and over and over again is, well, they don't want to start telling people about all the different things that they can refuse to do, because then they're going to get more people refusing field sobriety exercises. They're going to get more people refusing a breath test, or applicable blood test or urine test, especially, the likelihood of a urine or blood test goes up in car crash cases. This is only for car crash cases. And so with the police officers, the ones that have talked to me about it, they've said they'd rather risk the person's statements being suppressed by hiring a good lawyer than getting somebody to not give them the evidence of field sobriety exercises, of them having difficulty stumbling around, looking drunk, sounding drunk, or even worse than they may be, or, not giving a scientific chemical test. Obviously, Armand's going to talk about all the issues and problems with those tests, but they want to gather more evidence. So what's happening in these cases is police officers are choosing to violate people's constitutional rights. And they're making a calculated analysis to say, yeah, we're going to violate people's rights. But we know for that they're going to say, well, the juice is worth the squeeze. Okay. It's worth it to them to violate people's rights. Now, if the accident report privilege, if the judge agrees, and then what actually happens? Okay, you mute the audio. Doesn't mean that, right, the statements get suppressed. You mute the audio, but the jury, they'll still see, video and hear officer testimony about their observations. So it's like, I see you swaying, I hear you slurring, right? They'll still see the field sobriety exercises, all those other things. But really, any of the incriminating statements that a defendant made, such as, generally speaking, alcohol consumption, where they were going, where they were coming from, sometimes we don't want the video muted for the content, but we want the video muted for the slurring of it. And if it's slurring that is during this period, yes, that's gone, but the officer is still allowed to say, well, when I asked her questions, I heard slurring. Now, of course, if that's all off video, then the jury might not hear it, and it could be a conflict of the evidence, and it could be very helpful. So this is the part, accident report privileges, look at that as one of the big pieces of the block of ice that can be chipped away. This is not going to destroy the entire case. It's not going to snap your fingers and automatically make you win, but this is one big piece. Could be. one big piece to the puzzle to make an otherwise unwinnable case, DUI defense case, actually winnable. Um, and be prepared for the judge to fight you on whether Miranda must be read. There's been some new case law that's really taking away the accident report privilege. So you got to stay up to date on all the cases. It's very, very, very important because a lot of jurisdictions in Florida are trying to very quickly erode the accident report privilege, just like they've been eroding other things such as speedy trial, up at the Supreme Court level, Florida Supreme Court level. And so it's a really interesting time to be just a criminal or DUI defense practitioner. As the courts, the more conservative the courts have gone, how a lot of these rights and privileges that we've had over years and years are very quickly being eroded and kind of in their own ways chipped and chiseled away. All right. Field sobriety exercise. Okay, let's get into these. Let's really get into it. And I know Armand's going to talk about them as well. But an officer may request the driver to participate in field sobriety exercises if they have reasonable suspicion that a driver is operating the vehicle under the influence. Okay. The detention cannot occur unless the officer has some objective basis. Okay. Objective manifestation, objective basis that the driver is driving under the influence. Remember, it's reasonable, it's that reasonably objective standard that we're always talking about. Okay. Um, now, you can have some cases where the police are or the person is acquiescing to authority. Okay, that's something that you really want to be looking into, because a lot of times the police will try to trick somebody. There's things where they can make it seem like they're asking, but they're really commanding you. And especially some officers do cross the line with repeated kind of bullying. So I want on these type of situations, you have to go very slow in the body camera or whatever camera there is, if it's in dash or body camera, and you have to really look at it and don't just say, well, it's iffy, so I'm not going to file a motion, or, it's difficult. And we're probably not going to win, so I'm not going to file a motion to suppress. Okay. There's a lot of officers that truly not borderline, that truly badger people into doing these field sobriety exercises through tone, through intimidation, through continuing, asking or going at somebody. And um, I want everybody to know these cases, these situations can be won if you have the right facts. So don't just give up and say, "Oh, it's very difficult and they're voluntary, and if they do them, then they do them, and I'm not going to win a motion to suppress." All right. Um, all right, and here's, we're giving you guys a few different, good cases from either Florida Law Weekly or from the DCA. So definitely, like, you guys will get all these here, um, in the course materials. Right? There's involuntary versus voluntary consent. Again, a question of fact to be determined from the totality of the circumstances. Well, that's guidance, right? Right. Okay. And, so they don't really give much guidance here. And that's why it's so great to look at these Florida Law Weekly cases, because it's going to be so fact specific. And yes, it's more work. Okay. But the client deserves it. And this is how you win unwinnable or difficult cases. By having that get to yes mindset, that mentality of just being a little tricky and saying, right, and thinking about it. And look, when you file motions to suppress, you're putting the prosecution on defense. They have to defend against your motion to suppress. You're making prosecutors who are generally overworked and underpaid, you're making them do more work. More work you make them do, the better result you're going to get. And that is so important and such a valuable lesson that I've learned over my almost 20 years in criminal law, 2 years as a prosecutor, and 17 of owning the firm. So some key takeaways, just overall, is you gotta push the prosecution. They're not going to do anything until you start really filing motions and litigating these cases. And it's so important. And the very last thing that we're just going to talk about is probable cause. Okay. Here's a funny little, some people might think that's funny. Some people might not. Okay. Um, and just the last part is, okay, we have had many successes on no probable cause for DUI arrest, where we've been able to convince a lot of judges, well, there was reasonable suspicion uh, for a DUI stop, reasonable suspicion to do FSEs and start that process. But maybe the client did pretty well on them. Maybe the client refused the FSEs, and now there hasn't been enough evidence to rise to the level of probable cause for the offense. Okay. And this is the case out of Palm Beach County. Again, know your counties, know your judges, because there's nothing like seeing which judge that is in Palm Beach County and filing the same exact motion and going, well, judge, you actually said that the exercises are voluntary, and refusal to participate in the exercises is not what subjects the driver to arrest. Okay. So when you have things like that, it's so great. But the bottom line, right, the takeaways that I want just to kind of recap, okay? When police violate people's rights, especially the Fourth Amendment, especially in DUI cases, we're not talking about clients getting, victimized, beaten up, attacked, anything like that. That does happen in a lot of cases, not so much in DUIs. Most clients won't even know when their rights are violated. A lot of just general lawyers will have difficulty understanding and finding and seeing when people's rights are violated. DUI is highly complex, highly nuanced. It involves all the rules of the road. DUI is one of the most complex areas of criminal defense in a lot of ways. Not every way, but in a lot of ways, it's more complex than a second-degree murder, heat of passion. You come home, you see your wife sleeping with a pool boy, you pull out your gun, you kill them both. Okay. That's basically an aggravated battery with a death. It's a major case. There's a lot involved in it, but a lot of DUIs are more complex, especially with the rest of, what my fellow panelists will be talking about with that Manny, Armand, and Garrett will be talking about. You guys can really see that DUI cases are complex. So ask questions, think about it critically, okay, and file motions. Stay up on the law. Well, before you stay up on the law, understand kind of the foundational basic principles and then stay up on the law, because there could be 30 to 40 different ways to file motions to suppress, and good things happen when you file motions. That is a tenet of the Rossen Law Firm. We say it every week in our firm. Good things happen when you file motions. Good things happen when you file motions. Keep filing motions. Um, put the pressure on the prosecution, because there's nothing like having a tough factual case, filing that motion, and you're outside ready to argue it, or the day before the prosecutors call you and they give you that reckless driving or that careless driving, or so that way each party can get a little bit of something rather than one person get everything and the other person get nothing. And for a lot of our clients, they want that safety, and they'd rather take the safety and security maybe of a reduction down to reckless driving after by filing a motion to suppress, than risking it all on and seeing if the judge grants it or not. So there's so many great things that you can do. This is one of the essential fundamentals of DUI defense. I hope everybody here enjoyed this. I think we can go to break, and we'll have Manny jump up.